This is Michael Popak, and it must be time for Legal AF, the After Dark edition. Judge Merchan, the New York Supreme Court judge presiding over the criminal trial that led to 34-count felony conviction against Donald Trump's got his hands full. He's got Donald Trump on one side trying to argue that the recent United States Supreme Court decision in Trump versus the United States granted him immunity for all his bad criminal conduct and trying to cover up his sex act with Stormy Daniels, a porn star at the time, when he was running for office, even before he became president. I don't see that as part of Trump versus the United States, but it's something that's now going to have to be on a novel basis decided by the trial judge, Judge Merchan. So he's delayed the sentencing of Donald Trump that was scheduled for July the 11th and put it all off to the 18th of September to give the parties time to fully brief the issue, let the judge decide the issue, and whoever's the loser can then, we know who that is, can then take the appeal up through the state appellate process and maybe jump tracks and go over into the United States Supreme Court and try to get some relief there through a special writ. We break it all down for you the only way we know how, unvarnished, unfettered, unplugged, unfiltered on Legal AF. Take a listen. Let's turn to New York and turn it over to you. Turn the microphone over to you. Let's kick off with the immunity decision. Your old Manhattan DA's office making the decision not to oppose Donald Trump, trying to argue that somehow he's immune from his candidate Donald Trump attempts to hide his sex act with Stormy Daniels from the American public while he was running for office in October and November of that election year against Hillary Clinton. He cut a few checks and some invoices came in, all private checkbooks, private invoices to Donald Trump. He happened to be sitting in the Oval Office at the time that he did it. But you can then take your analysis of the various absolute and rebuttable presumption immunities and apply it to this and tell me what you think is going to happen in New York and the timeline related to it as we move into a new, updated, continued hearing date of September the 18th.
Yeah, I'd love to hear if you agree with my assessment here. So this is really interesting how this immunity decision applies to New York and the conviction that just happened. A couple of things just to kind of level set. There's a post-verdict motion in New York called a 330 motion. It just essentially means anything from the time of a verdict before sentencing, that little window, that's your time to file any motions you have about the trial, about the verdict that you want addressed before sentencing. And it's so that it becomes part of the record so that if you appeal, it will be part of the official case record. So that's the posture we're in. The judge gave Donald Trump until June 13th to file any 330 motions. He didn't. And then this decision came down on July 1st. So some people were arguing, well, he missed his deadline to file a 330 motion. No surprise that Judge Merchan is giving him a chance to do this. How could you file a motion if the decision hadn't even come down yet? So that doesn't surprise me at all. It also doesn't surprise me that Donald Trump would ask that they have an opportunity to brief this and to put off the sentencing. I'm also not surprised that the prosecution consented to an adjournment and wants this briefed as well. Because what has to happen now is the exact same thing that Judge Chutkan is doing, which is make a record of what's official and what's unofficial and just make a finding. And a judge has to make a finding. And so that's what Judge Merchan has to do. Unlike Judge Chutkan, however, who has to hold hearings and have evidence and have testimony and actually analyze things, that already happened at the trial. Every single witness, every piece of evidence, it's all in. And not only is it in, and it was also cross-examined vigorously by the defense. And so it's all out there. All the judge has to do is apply the law to the facts and make a record. And so that's what he needs time to do. And that's why he put it over until September 18th. Now, what he said was his decision will come before September 18th. I can't remember the date, but a week before, I think. And then he said these ominous words, and if necessary, a sentencing will be on September 18th. And everybody clutched their, gut and said, oh my God, what do you mean if necessary? Does that mean it's going to impact it? It's typical Judge Merchan to put it that way. He doesn't prejudge anything. He leaves everything open. And so, look, this could theoretically impact the case. If he's immune, if this is all official conduct, yes, the conviction would get thrown out. That being said, I think it's very clear that most of this case, if not all of this case, will be fine. And it's for several reasons. Number one, Donald Trump, and through his lawyers, is on record saying this is personal conduct. Don't forget, there was a removal hearing to go to federal court. And in the removal hearing, Judge Hellerstein, there were proceedings and motion practice and hearings because Donald Trump didn't want to be prosecuted in state court. He wanted to be removed because he was a federal officer to federal court. He thought he had, I think, better luck of the draw of having a better judge. I don't really know why they want to get removed to federal court, but that's what they wanted. That's what he wanted. And during that proceeding, that a lot was conceded and put on the record and found by a federal judge already. And so there's no doubt that this is all private conduct and personal conduct. He also withdrew he made a presidential immunity claim and then he waived it. He withdrew it. So that issue is not necessarily preserved here. That being said, I do think the judge will apply this new law to the facts. And the only facts that I think are going to be in this category of presumption or that might fall into this presumption category. In other words, he gets the presumption that it's official, but then the prosecution has to overcome it, and I think they do, has to do with Hope Hicks' testimony. I think her name was Madeline Westerhout's testimony. I mean, these were White House employees. Okay, these are conversations between Donald Trump and White House employees. I think
part of Hope Hicks. She was also the campaign president.
Yes, that's true. That's true. Part of Hope Hicks. I think that gets you into the presumption. I think that makes it presumptively immune because it's because they're employees of the White House. That's part of talking to them openly and unfettered, vigorously and energetic. But that's how you overcome the presumption. So right, but I'm first you have to be put into a bucket.
You think if the conversation takes place in the Oval Office, it's automatically official conduct?
I think it's presumptively official, and then you have to overcome that. You have to rebut the presumption, and so there's certain things that aren't presumptive, right? Conversations with Jeffrey Clark, that is official conduct. Period. Full stop. Cannot even. There's not presumption. There's
that's
no
core.
way.
That's even core.
That's my point. Yeah, that's what I mean. That's core official conduct. And so that you can't rebut that. There's no that's a it's out no matter what. There is this gray area that you are presumed to be immune, but you can rebut it. It can come out. And I do think those fall into the presumptive category because they're White House employees working for the president and they want to promote a vigorous and energetic, not looking over your shoulder presidency. So I think I think those two witnesses go into that presumptive bucket, but I think the record easily overcomes it because it was about personal matters. It was not about anything official or presidential. So I do think those witnesses. And then the next area where I think is also going to fall into this presumptive category is going to have to do with the tweets that were from the White House Twitter account that were put into evidence. They will say, they specifically said communication with the public in this decision. They said communication with the public is a core, is a duty, is part of the presidential function, and I think that's going to be also presumptive. He's going to be in the presumptive immunity category that can be rebutted by other evidence. I think it'll all come out. I think those are the only pieces of evidence that I can think of that will be impacted by this at all. I think they will be found to be unofficial as opposed to official and therefore not subject to any of this. However, I do think you're going to hear the judge say, even if I'm wrong, the evidence is overwhelming and it's harmless error. So even if I made the wrong decision and it turns out those pieces of evidence should not have come in, then I think he's going to do a harmless error analysis, and I think he prevails. So I do think that the conviction will stand. I think it'll be okay. I do think the sentencing is delayed. I think there will be a sentencing. And as I've said many times, I think he will receive a sentence of incarceration. But this decision, to me, makes it even more likely that the judge will stay sentencing or pause the sentencing pending appeal, because obviously now that the immunity decision's out, there's a significant issue that needs to be reviewed. So he will, that's my kind of prediction of how things are going to go here.
Yeah. So you're on incarceration now, no longer subway litter picking up, right?
Yes, I have, because, you know, when you look at the other cases that have received incarceration,
Yeah.
you can't ignore that this is by far the most serious of them. You know, it's only 20% or so of this people charged with the statute who have received incarceration. However, they when you look at the facts that support that and the egregiousness of it, this makes them look petty. And in addition, when you add his post-trial conduct, all the threats and the baseball bat and all that stuff, and you look at his being held in contempt 10 times, and you even look at his I'm sorry, that was pre-trial conduct. You look at his post-trial conduct, you know, where he doesn't take responsibility for his actions and he shows no remorse, etc. I really think that all of those factors will lead the judge to have no choice but to say, look, if I'm going to treat you like every other person, anyone else who's not named Donald Trump, who is in this position with all the things that I just described, you have to sentence him to incarceration. He's just not going to go to jail until after his appeals are up.
Yeah, you and I come to the same exact place from slightly different angles. I don't think because it happens in the White House that it automatically converts into official acts. If you read the majority opinion, this is the basis I'm using. Taking into account, this is from page 14, taking into account these competing considerations, we conclude that the separation of powers principles explicated in our precedent necessitate at least a presumptive immunity from criminal prosecution for a president's acts within the outer perimeter of his official responsibility. I don't see him directing the payoff of Stormy Daniels and repaying Michael Cohen out of a private checkbook to even be within the outer Blassingham perimeter of official responsibility. So I don't think you have to even get to the rebuttable presumption, because let me finish my thought.
Sorry.
And so it's either one of two things. It's either, as you said, it's an official conduct. So because of all these people's involvement, and then you need to rebut it, and they will successfully rebut it, or you never have to get there because it's an unofficial conduct that is prosecutable. And I'm in that last category.
So I completely agree with you that paying a porn star and all, everything you just said is unofficial. And so I don't think the conviction will stand. I'm talking about the part of the decision that says the evidence.
Oh, okay. You're talking about all right. I agree with you there, that the evidence about covered conduct should not have come in. And I agree with you that the judge should find, and the appellate court should also find, that it is harmless error. But just to leave the note, to square the circle here, he's going to make his decision, Mershon. He may or may not sentence he said, I may or may not sentence. It depends on where we are in the briefing. The first line of appeals, to answer a prior question about why did they want to take it to federal, because they wanted to stay in the federal track, federal appellate court, federal Supreme Court, straight shot. Here, they got to go through, arguably, they got to go through up to the Court of Appeals in New York. Then they're going to have to try to jump the track with a writ to take it over to the United States Supreme Court, which is sort of, and that's delay. He may sentence and then suspend, waiting to see how this immunity thing plays out. But I agree. There should be no immunity for this, even under the outer perimeters of everything we've just discussed, and that Mershon's going to find that there's no immunity for it. And any of the other evidence that was let in, which was relatively minor, Hope Hicks mainly testified about how the campaign freaked out when they found out about the hot mic moment in about Access Hollywood, with Trump bragging about grabbing a woman by her vagina, which he can get away with because he's a celebrity, and how they then that lit the fuse for the catch and kill program through the National Enquirer, Michael Cohen, David Pecker, Donald Trump, the three co-conspirators in the Trump Tower conspiracy. That's real. Yeah, she talked about him. Well, he gets mail, and he was very concerned about the articles and the media. And then I couldn't believe I was even picked, as I really wasn't qualified to be a communications director. And yeah, I get that. That's why I totally agree with you on the harmless error thing. Welcome back. We do that show twice a week, Wednesdays and Saturdays at 8 p.m. Eastern Time on this YouTube channel from MeidasTouch. Free subscribe and help them get to 3 million free subscribers. We're literally building this network with our bare hands without outside investors, and you are the network you've been looking for. It's right here on the MeidasTouch network. If you like what we're doing, you can leave us a comment, rate us, participate in our live chat during the actual recordings on Wednesday and Saturdays at 8 p.m. Eastern Time. And then you can pick us up on all audio podcast platforms of your choice. If you know all about Legal AF and you saw that particular episode, or maybe you missed it and there's the clip, take that clip, a mini bite-sized version of Legal AF, send it off to people in your life and ask them to join our audience as we continue to try to build towards November. If you don't know about us, I invite you to use that as your opportunity, that clip right there, to join us on Wednesdays and Saturdays, 8 p.m. Eastern Time, and become part of our growing audience. So until my next hot take, until my next Legal AF, this is Michael Popak reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.